May it please you, my lords, my lady, in this appeal I represent the appellant husband, this gentleman here, my learned, with Mr. Magpul, I should have said, I forgot to interrupt him, I'm so sorry, and my learned friends, Mr. Todd and Mr. Kingscote and Mr. Harris, represent the respondent wife, who's the lady with the white top over there. Although the parties were divorced by decree absolute in June of 2007, a long time ago, I will, with your lordship's and ladyship's permission, refer to them as the husband and the wife. And by the same token, I propose to refer to the agreement, which will be the subject of debate in this appeal, as a prenup, if I may. It's referred to in many different ways in the cases, but I shall refer to it as a prenup. Now, my lords, my lady, my oral submissions have 5 themes, and some of those themes have sub-themes, and in the interest of saving your lordship's and your ladyship's pen, I produced a list of the outline, the route map of my submissions. And I'm first going to ask the question, is this a Crossley type case? I'm then going to ask, my second theme is, was the Court of Appeal decision permissible? And as to that theme, I'm going to ask first, did this amount to a revolutionary piece of judicial legislation, or was it merely a factor-specific decision correctly applying the existing law? Secondly, I shall ask, under this head, was it permissible for the appellate court to ignore MacLeod? And thirdly, were they entitled to interfere with the learned judge's exercise of discretion? I'm then going to, as my next theme, address, quite briefly, the great debate. Firstly, the pros and cons of prenups, and secondly, the arguments for reform. I'm then going to turn to other countries and look at the nature of legislation where it has been adopted by common law countries, and to look at those few instances where change has been effected by judicial intervention. Thirdly, I'm going to look at Europe and the impact of community law. Fourthly, I'm going to look at the vexed question of the impact of personal law in the ancillary relief exercise. Next, I'm going to look at the impact of a foreign proper law clause in a nuptial agreement, and then I shall look at the analogy of your lordship's and ladyship's recent decision of Agbaji. And then finally, I will look at this case in particular, the effect of the judge's decision for the husband, the effect of the Court of Appeal's decision for the husband, the aptness of a Children Act solution, and finally, the practicalities of a trust solution. So is this a Crossley type case? If your lordships take the authorities bundle 4 and turn to tab 60, you will find the decision of the board in MacLeod. And on page 449, paragraph 28, my lady stated this: an example of the, quote, right case, unquote, is Crossley, where the Court of Appeal upheld an order for the wife to show cause why the terms of an antenuptial agreement should not be implemented without further ado, an order of the type made in Dean. But Lord Justice Thorpe observed that all these cases are fact-dependent, and this is a quite exceptional case on its facts. But if ever there is to be a paradigm case in which the court will look to the prenuptial agreement as not simply one of the peripheral factors of the case, but as a factor of magnetic importance, it seems to me that this is just such a case. Now, my lords, my lady, in our printed case, we argued at paragraph 117, you needn't turn to it, that's at page 53 for the note, that in the Court of Appeal, Lord Justice Wilson did indeed treat this as a Crossley-type case. We have argued that Lord Justice Thorpe and Lord Justice Ricks subjected this decision of Mrs. Justice Barron to a narrow textual analysis, to quote Lord Hoffman's famous phrase in Pigloska, enabling them to say that the judge's discretion miscarried by failing to give sufficient expression to the discount that this flawed prenup attracted. But Mr. Todd, in his printed case, says no. If you turn in the bound volume to the final tab, the first bound volume, the final tab to page 45 in my learned friend's printed case, you will see at paragraph 6.12.1, there was no division between the judges in the Court of Appeal. This was a powerful decision by a hugely experienced Court of Appeal. They all agreed that this should be treated as a Crossley-type prenup, hence it being given decisive weight. And so it would appear, my lords, my lady, that Mr. Todd's defence of the Court of Appeal's decision depends centrally on him being able to demonstrate to you that this is indeed a Crossley-type case, an exceptional case, a case that is another paradigm example for treating the prenup as a magnetic or decisive factor. So perhaps we now look at Crossley in volume 2 at tab 37. Rather than divining the facts from the headnote and the text, I just tell your lordships that these were the relevant facts. The husband was 62. It was his second marriage. He had 4 children from his first marriage. The wife was 50. It was her 4th marriage. She had 3 children from earlier marriages. They met in June 2005. They were engaged in September 2005. And from that point until November of 2005, they negotiated a prenup through separate, independent, highly experienced London solicitors. The husband in that process declared 45 million, the wife in that process declared 18 million, and they signed the prenup on the 16th of November 2005, which provided for a mutual waiver of claims. They married in January 2006, and separated 14 months later in March 2007, and unsurprisingly, they had no children together. The wife petitioned for divorce in August 2007 and filed a claim for ancillary relief in September of that year. In those proceedings, she said that the husband's declaration of 45 million was inaccurate. This was a completely spurious allegation, and it was perhaps the most meritless ancillary relief claim that it's possible to imagine. Now, on the 20th of September 2007, the husband issued his Dean summons, as my lady pointed out in MacLeod. And on the 30th of October 2007, Mr. Justice Bennett decided 3 things. 1, there would be an abbreviated ancillary relief hearing in January 2008, at which the court would decide whether to give effect to the prenup or not. Secondly, the wife was to set out her allegations of underdisclosure in a solicitor's letter. Thirdly, the parties were to file Forms E, but without reams of supporting documents, and the husband was to answer the solicitor's letter in his Form E. The wife then went on to appeal that case management decision. She wanted a full-scale ancillary relief hearing with reams of discovery, interrogatories, and the rest. And the Court of Appeal dismissed the appeal in December 2007. So this was not a decision that upheld the prenup. It was a decision to uphold Mr. Justice Bennett's decision to hold an abbreviated hearing with attenuated documentation. And after the appeal decision, the case settled. Now, it's easy to see, my lords, my lady, how this case, on its facts, is leagues away from Crossley. So how does Mr. Todd explain his submission that this was, in fact, a Crossley-type case? He does it by recasting the facts in his submission in a way that is totally at variance with the actual evidence and the judge's findings. He recasts the evidence and the findings to shoehorn this case into the Crossley box. What does he say in his case? 1. Although there was a full disclosure exercise in Crossley, the absence of such an exercise here did not matter, because the husband here knew all about the wife's great wealth. 2. Mr. Todd says, at the time of the prenup, the husband was just as rich as the wife, if not actually so, then certainly contingently. And thirdly, he says, just like the exceedingly rich Mrs. Crossley, the husband will not now face any hardship if this prenup is upheld because of A, his prospective inheritance, B, the current actual subventions from his father, C, his earning capacity, and D, his ability, as explicitly found by the judge, so says Mr. Todd, to trade down from his £2.5 million house and to release equity into his Duxbury fund of £1.5 million. Now, as to the first point, my lord, the husband's knowledge of the wife's wealth. Could you turn in Mr. Todd's printed case to page 28, which is paragraph 4.9c. I notice that some of your lordships are not working off the brown volumes, and there may therefore be some pagination misfit, because the bound volume has acquired slightly different pagination to Mr. Todd's original one, because there's been a bit of a makeover given to Mr. Todd's original one. I'm not complaining at all, since before it went into the bound volume. So if I give the wrong page number, I apologise.
I think we probably can find it by paragraph numbers.
Yes,
to give those.
This is 4.9c, my lord.
Yes.
He says in this paragraph, in the second sentence, the husband knew that the wife was from a wealthy background. Detailed disclosure of her means, resources, or even expectations would have made no difference to him signing this agreement. It is not alleged, says Mr. Todd, that the wife sought to conceal her wealthy background, nor is it asserted that any lack of disclosure made any difference to the husband's assent to this agreement. Now, I ask rhetorically, how can Mr. Todd credibly say that the wife did not try to conceal her wealthy background when such concealment was the judge's actual finding?
Well, there's a difference between wealth and wealthy background.
Yes. Well, there is a difference between wealth and wealthy background, but yes, as we will see, my lords, Mr. Todd uses the language very carefully, wealthy background, the Court of Appeal talk of specific knowledge of the wife's wealth. We will find that that is just simply not a finding that the judge made, and nor was it a basis on which the Court of Appeal could have made its decision. Now, in order to understand the judge's finding, which is in a sense more important than perhaps what Mr. Todd says in this paragraph, I want to look very briefly at some passages in the affidavit evidence. Could you turn in Appendix Part 3, page 240, please. As to wealthy background, there's evidence given about this as well. This is the husband's maintenance pending suit affidavit of the 12th of June 2007. And in paragraph 6, which is at the top of page 240, he says in the fourth line, at that stage, it says the stage, that's a typo, at that stage, I did not know, this is signing the agreement, what the respondent was worth or what she might be due to inherit, although Catherine's family appeared well off. If you turn on to page...
Most significant chunk of wealth is neither, isn't it? It's a settlement after marriage, but before the wife's father's death.
Yes, quite. If you turn to 262, the Lordship makes a point for me which I was going to make later, so that will attenuate my submissions. If you turn to page 262, this is the husband's affidavit about the prenup, which is dated the 12th of July 2007. At paragraph 3, it is said, Catherine's family appeared well off, but during the course of our relationship, Catherine had not at any stage mentioned to me what she was worth, what she might be due to inherit, or the extent of her family's assets. And if you turn to paragraph 10, it says on page 264, I did understand that Catherine's family appeared to be well off. At no stage before or after engagement, however, had Catherine led me to believe what she was worth financially, nor what she might be due to inherit.
As you pointed out, the statement in the case is rather carefully worded because it's talking about concealment.
Yes.
Now, there is nothing in these passages about concealment. This is simply a lack of information about detail. But
we're coming to concealment, my lord.
Are you? All
We
right.
are. We're coming to
At the
concealment.
moment, I don't quite see the point. But
We're coming to concealment. There are 2 points here. Is what was his actual knowledge and where was there concealment? So I'm dealing with the first point here and I'm going to come to concealment in just a minute. If you take Appendix Part 4, his affidavit in reply, page 135, and this is dated the 17th of June 2008. He said in paragraph 4, Catherine has suggested I knew broadly that she and her family had substantial wealth, although she accepts I didn't know precisely how much. The truth is, at the time of signing the antenuptial agreement, I did not know, even broadly, the extent of Catherine and her family's wealth. Things progressed incredibly quickly between Catherine and me. We met in November, we were engaged in June, we signed the antenuptial agreement in August, we were married in November. We didn't discuss the extent of Catherine or her family's wealth, nor was that wealth particularly evident. She was renting a perfectly nice one-bedroom flat in Chelsea. I visited her parents' chalet in Verbier. However, the house in Germany was quite ordinary. It had shared bathrooms, no great art, no evidence of conspicuous consumption. She says it was a simple but comfortable property. Then he talks about cars. So that was the husband's evidence. Now, it is true that the wife's evidence, if you go back to Appendix 3, was different at page 113. At paragraph 4, in her affidavit on the 10th of May 2007 about the prenuptial agreement, it was said in paragraph 4, by the time of our engagement, Nicola knew I was financially independent. We had several conversations about my wealth and that of my family. He knew I came from a family whose wealth went back several generations. He made it clear to me, both before and our engagement, he didn't want a penny from me and that he would sign a prenuptial agreement. And in part 4, at page 51, she says in her main affidavit, paragraph 15, I did not discuss with Nicola when we first met the precise details of my family's money or what I had already been advanced, but he had a broad idea of the position. He knew from me broadly that I and my family had substantial wealth, but he didn't know, I believe, precisely how much. He was on track to become extremely rich himself and had his own family money behind him. He asserted he wanted to put himself in a position to pay for everything, as was the Latin way in which he had been brought up. So, faced with that evidence, what was the judge's finding? I should say that we've recently received the transcript. There was some brief exploration in cross-examination of the husband where he was consistent. He repeated he did not have conversations with her about her own or her family's wealth. And what were the judge's findings? So if you turn in to Appendix 1, the bound volume, I don't know where it's more convenient for your lordships, but to the judge's judgment at page 77, paragraph 23. The learned judge says at paragraph 23, page 77, I do not believe that either party was deliberately lying to me when giving their version of events. I expect that after some 10 years, their recollections are clouded by the importance which the PNC has assumed in this litigation. Unravelling the various contentions, I consider and find that the husband was told by Mr. Radmacher Sr. wanted the contract signed. The husband was eager to comply because A, he didn't want the wife to be disinherited, B, he wanted to marry, C, he could not perceive of circumstances where he would wish to make a claim. For her part, although I'm sure the wife wanted to love her husband to love her for herself, she emphasised her father's insistence about the prenup because I suspect she felt it made her seem less insensitive to her future spouse, given that the deal was to exclude all his potential rights, even in times of crisis. I do not believe that she made it obvious that she personally demanded it as a precondition of marriage. So there was, my lords, in this judgment, no finding at all as to the husband's knowledge, even broadly, of the extent of the wife personally or of her family.
What about paragraph 22, third line?
She presented the need and driving force behind the prenuptial agreement being
No. First words of the third line.
He informed me, the husband had a slightly different take on their discussions. He informed me that the wife stated that she would be disinherited if she married without a prenuptial agreement which protected her family wealth. Yes, well, the husband had said in the passages I'd read to your lordship that she did say that if there was no prenup, there would be no inheritance. That is at Appendix 3, the antenuptial affidavit at paragraph 10. So I accept that the husband had said, this is as far as he went, that if there was no prenup, the wife might be disinherited. But as to the scale of the wealth, she was never given any information at all, and there was no finding. And there was particularly no finding at all as to the wealth of the wife herself. Now, by contrast to this, my lords, there were specific findings of the wife's attempts and intentions to conceal her wealth. If you look at paragraph 29, at page 78, you will see the learned judge says that on the 17th of July 98, the notary sent a letter with a draft contract enclosed. It was addressed to the wife, although at Elm Park Mansions, although by this date it would seem she was already living with the husband in Sumner Place. Dr. Magis, he's the notary, cannot recall if he posted a copy. In any event, it didn't matter because he faxed it to Beecham Place. The letter stated, you wanted to discuss the content of the agreement with your future spouse and have it translated into a language convenient for him. The draft which was sent had included a term, we put the net value of our combined assets at some blank Deutschmarks. Of this, approximately blank Deutschmarks is attributed to the husband and blank Deutschmarks to the wife. It should be future wife. Later that day, the wife phoned Dr. Magis and informed him that she had discussed the content with her father. She had to discuss the content with her father. However, she wanted two minor amendments. Value of assets, not to be in the deed, but notified separately. She would pay the costs. It would seem that the notary's scale fees were based on the value of her assets, which, according to his papers, were put at a modest 1.4 million Deutschmarks. This sum was calculated on their real value, which he stipulated was just over 1 million Deutschmarks, plus notional values for the waiver of rights in relation to pension maintenance and statutory proportion. Apparently, the doctor had the relevant information on file as a result of previous work undertaken by him for the family. This very precise figure does not represent the true value of her wealth, because, as I perceive from the evidence available, she also had company shares that produced 500,000 Deutschmarks per annum and monies that had been invested on her behalf by her father. If you turn to paragraph 38A, the learned judge, having set out that evidence, concluded as follows. There was no disclosure of the parties' assets. The clause was originally included, but was omitted on the direct instructions of the wife. This was deliberate, and having heard her evidence, I am satisfied that she did not discuss this decision with her future husband because she wanted to keep her asset base secret. Indeed, even before me, she was cautious in her answers about her worth at that time. she suggested her own assets were about 1 million Deutschmarks. Of course, that answer, and similar information as to capital given to the doctor for the purposes of his scale fees, was incomplete, because she held 6% interest in the companies which produced a substantial income plus funds which had been accumulated over time and invested, husbanded by her father. The value of her shares and the accumulated income in 98 remains unquantified and was not even disclosed to the notary. The lack of proper disclosure wouldn't affect the validity of a prenup in Germany, but I consider it is a relevant factor under English law, because without full knowledge of the assets, it is impossible for any party to make a fully informed decision. So there is nothing in the judgment, my lords, let alone a finding, that the husband had any idea of the wife's personal wealth. All he had said was he understood that the family was well off and that but for a prenup, the wife faced a risk of disinheritance. He had said that the family lived thriftily and there were positive findings by the judge of concealment. And so, in the light of that evidence and those findings, we turn to the Court of Appeal judgment, which is in Appendix 1 at page 19. First reference I want to make. At paragraph 33, Roman 5. Paragraph 33, Roman 5, as I said. Although the exclusion of an account of the wife's assets was the intention of the wife and her father, the husband well knew that she was a daughter of a significantly rich family. What was hers at the date of the marriage was likely to be of lesser significance than what was to come to her as her generation took control. And we ask, where does Lord Justice Thorpe get this from? He doesn't get it from Mrs. Justice Barron's judgment, nor does he get it from the evidence. And it's the same with Lord Justice Wilson at paragraph 141, which is on page 50. In a passage which I will come back to, which is the famous causation passage, which is of some significance, Lord Justice Wilson says in the 10th line, he knew, that's the husband knew, that the wife already had substantial wealth, and he showed no interest in ascertaining its approximate extent. Now, this is a very important finding. This finding is where Lord Justice Wilson builds his theory of causation. But there was no finding that the husband had any knowledge as to the extent of the wife's wealth, nor was there any evidential basis on which a finding could have been made. So we have here, first, good example of alteration of the facts to suit a desired objective. The judge did not find that the husband knew even approximately what the wife or her family had. All she found was that the wife had said she faced disinheritance if there were no prenup. But the Court of Appeal, as I've said, in order to establish this novel theory of causation in relation to disclosure, creates this finding, and now Mr. Todd reiterates it to fit in with his central argument that this is a Crossley-type case, where non-disclosure does not matter because the husband had full knowledge of the extent of the wife's wealth. Now, Mr. Todd's second point is this. At the time of the prenup, the husband was just as rich as the wife, if not actually, then certainly contingently. On no less than 6 separate occasions in the printed case, this point is made by Mr. Todd. First, on page 4, at paragraph 1.2b10. Mr. Todd says, any future inheritance that the husband might receive from his multi-millionaire parents will be free of claim by the wife it was protected by the wife's mutual promise not to claim against him in the prenup. The husband's evidence that they were only worth €7.5 million was rejected by the judge. The wife's case, that they were worth £20 million to £30 million, was unimpeached. If they have retained their domicile in France, half of this must come to the husband to be shared with his sister. You turn on, please, second of the 6 to page 26 at paragraph 4.5. The Maloney friend says at paragraph 4.5, the first point to note is that the husband also expected to gain from this agreement at the time of its inception. His considerable inheritance would not be subject to attack. At page 36, point number 3, which is the end of paragraph 4.12, he says this. In the second line, at the time of the agreement, he was arguably in as strong an economic position as the wife. And on page 39, he says at paragraph 5.3d Roman 4, 5.3d Roman 5,
did you say 5.3?
5.4. This is.
It's 5.4.
I'm having a terrible Jack.
Yes, I think it's 5.4D, Roman 3.
5.4.
Yes.
D.
Yes.
5.
Yes.
That the wife has expressly repudiated her inheritance on the basis of this agreement. The husband is in a far happier position. He is one of 2 children of French multimillionaires. His evidence that they were worth only €7 million was not accepted by the trial judge. The wife's suggestion of £20 to £30 million was not similarly impeached. Moreover, the wife's figures are much more consistent with the tax exile status of his parents. Furthermore, as the husband's parents had probably retained their French domicile, then their testamentary intentions are prescribed by French law. This husband will share with his sister in his parents' fortune. And then, the next paragraph, Romans 7, penultimate sentence, in reality he can afford to do this. He has an expectation of parental millions. And finally, at page 49, at paragraph 6.17, he says the husband, in the antepenultimate sentence, the husband might then have had to have disclosed his own family's great wealth. He chose not to do so. Again, we say, in these 6 instances, these are examples of Mr. Todd constructing findings that were simply not made in order to bear out his central thesis that this is a cross-slate type case. If you could take, please, volume 4.
Just before we move from that, it's recorded in the printed case that Mrs. Justice Barron did not find that it would have made any difference if disclosure had taken place. Is that accepted?
Yes. No, I beg your pardon. It's recorded. It would not have made any difference if the husband wouldn't have signed if he had known about the wife's wealth and full disclosure had been made. I don't know the answer to that question. That's a counterfactual question, my lord, as to which there was no evidence given below.
Well, let's concentrate on what is asserted in the printed case and see what your position is. Disclosure in this case would not have made any difference. Mrs. Justice Barron did not find that it would have done. What's your position about that?
I can't. That is a counterfactual question, my lord, and I'm not able to give you an answer because that was not explored in the evidence. As we all see when we travel a long way to New Zealand and Australia, that there is a statutory exception which permits this sort of inquiry to be made, but it has to be the subject of evidence. And this was not the subject of evidence. So I cannot go on a counterfactual journey with your lordship and say, had the wife told the husband the truth and not concealed her position as she did, that he would have signed, or would he have negotiated something?
I don't want to embark on any journey. I just wanted to hear what your submission was on this.
The answer,
point.
the answer is, I don't accept that.
Yes.
He's an intelligent man. He must know that her wealth could range from, clearly, sufficient to very large, and her expectations even more so.
He might have done.
Yes, well, he clearly wasn't interested, and for understandable reasons. It's a rather odd
Conception that you say before you were married. I won't agree this unless you tell me that you're, if you tell me that you're worth 20 million, I will agree it if you're only worth 5 million.
It is odd, but if we're going to be in the world of negotiating a prenup, there has to be disclosure and knowledge. You have to not only know what they're worth, but you have to know what you're giving up.
Well, I think
And so I
that's-
can't answer your lordship's question. I mean, this was the debate in the Court of Appeal. He was a man of commerce. He was an intelligent man. As if all intelligent men, therefore, do not need legal advice and disclosure. But that doesn't follow. In a sense, they almost need more legal advice and disclosure because they get overwhelmed by their own cleverness.
I'm sure you'll come to it. Perhaps that's a danger, a general danger.
I'm coming to that.
But I did notice Mrs. Justice Barron's statement. Without full knowledge of the assets, it's impossible for any party to make a fully informed decision. It
Yes.
seems to me that's simply, on the face of it, a circular statement.
It's
True,
not.
if you don't have full knowledge, you can't make fully informed decision. But if you're an intelligent man, you may not be interested in making a fully informed decision.
But the scheme of the statute, as we will see, wherever it has been adopted in the world, requires you to have, the scheme of any reforming statute, and we can look at wherever it is in the world we will, they always require full knowledge of what they have and what you're giving up. And there is a very substantial comparator to be made for agreements in the employment and discrimination field. You might say, well, why does the statute say in employment and discrimination that you need to have full advice and know what's going on? You're an intelligent person, you're signing this agreement. There is a reason for it, a policy reason which I will come to.
Well, the reason may be that some people are intelligent and some people are not, and if you're laying down black and white rules, you've got to cater for the latter. It doesn't follow from that if you have a situation where you needn't cater for the latter, you should say, well, because the black and white rule wasn't satisfied, ergo this has great significance.
I would suggest that there is a reason for a black and white rule, is that it's so easy to say if you have an ideological agenda, as we the Court of Appeal had in this case, that, oh, he's clever, so he did not need to know either what she was worth or what he was giving up, because he's clever. So that's, instead of there being one law for the rich and one for the poor, it's one law for the clever and one law for the stupid. And so, in my respectful submission, when I come on after this bit of my submissions to, I think it's my third or fourth theme, I'm going to be looking at this in some considerable detail. When I say considerable, I don't mean long, I hasten to add, in some detail.
I think that's a miscategorization to suggest
That it's a different law for the
intelligent. The law actually takes account of the facts, and if someone is intelligent, that's as relevant a fact as any other fact.
My lord, you do not need to be a man of commerce or a sophisticate to know what the literal meaning of you are getting nothing means in a prenup. Anybody knows what that means, provided they're fluent in the language of the contract or have had it explained to them. You don't need to be clever at all.
So it's not simply a question of intelligence, of course, it's also evidence of disposition. In other words, whether or not it was a matter that was going to weigh with him in any event. And that's surely relevant, isn't it?
Whether it would have made.
Yeah.
Well, in that case, you have to have an inquiry on that counterfactual basis, as the Australians and New Zealanders would, with the burden of proof, I would suggest, being plainly on the person who is trying to uphold the agreement to demonstrate that proposition. That is what the cases in Australia, well, not Australia because they've only just adopted this, but in New Zealand, have required for a long time, and that is manifestly a right approach. In this case, Lord Justice Wilson would reverse the burden and say, it's for you, Mr. Granatino, to demonstrate that it wouldn't have made any difference. You have to demonstrate that. And we suggest that that's obviously wrong and unfair. And so I am going to come back to this when I talk about matters more conceptually, as opposed to the specific facts of this case. I do not agree at all with my Lord Kerr's point that disclosure in this case would not have made any difference. We just simply don't know the answer to that question.
That's not my point. I'm simply quoting from the respondent's case.
I understand that, my Lord. I wasn't being obtuse, I hope, and I understood the point entirely. Now, can you look, please, at, in relation to this point, which are in a slightly different area we are here, we're talking about my second point. At the time of the prenup, the husband was just as rich as the wife, if not actually, then certainly contingently. If you look in the Section 25 affidavit of the wife, in Appendix 4, at page 64, in paragraphs 53 to 56, I don't propose to read them. What the wife effectively says is this. She says, the wife says, the husband comes from a very wealthy family. Her inheritance has been transferred to her. She expects the husband's parents to make advance transfers to him after the case has been completed. But in 2003, his parents gave him £300,000 and she doesn't know what happened to it. She believes, she says here, top of page 65, that his parents have between 20 and 30 million pounds. The only difference between the parties is that the husband has received no inheritance as yet and the wife has. And in his response, what the husband said at page 136, at paragraphs 6 to 11, again I summarise, he says he's spoken to his father, that the wealth of his parents, $7 million. His father has
Sorry, what page was this?
So sorry, 136 in Appendix 4.
Paragraph 6.
Paragraph 6 through 11. What the husband here says is he's spoken to his father, that his father has told him his wealth is about $7 million, that he values the property in Antibes for French wealth tax at €800,000, that he rents a flat in London, that he's lost about $2 million. He says in investments, his father's only 64, his mother's only 61. He says both his paternal grandparents are alive. He says it's not true that he's going to inherit millions prior to or after his parents' demise, that they intend to spend their money on their retirement. So that was the evidence before the judge, wife's and the husband's. What was the judge's finding? It's in page 75 of the judgment, page 75 in Appendix 1. At paragraph 18, it says the husband was born in July 71 in Antibes. His one sister, he's French, Italian ancestry. His father worked for IBM prior to his retirement and was at one time in charge of its European operations. The father was obviously a successful corporate businessman. He now lives in London for tax reasons, although he retains his property in Antibes, supposedly worth $800,000, and is subject to the French rules of forced heirship on death. The wife claims that the husband's father spoke of his wealth being 20 to 30 million pounds, and so she maintains that the husband will receive a substantial sum by way of inheritance or gift when this litigation is completed. The husband asserts his parents are worth a much more modest €7.5 million. I am in no position to make any findings on the basis of evidence I have heard, but I have doubts that Mr. Granatino Sr. would be resident here for tax reasons on the basis of the figures suggested by his son. However, his wealth is of little direct relevance to me, because as a resident of the UK has freedom of testamentary disposition, with the result the husband cannot be sure of a share, save in respect to the French house. Authority makes it clear that a possible inheritance is no more than a background factor. That stated, the wife has already received her inheritance, waived her rights under German law, so to that extent the parties may, and I stress may, be in a different position. The husband claims that she will receive additional funds which are currently held in a Swiss foundation, but I'm not satisfied on the evidence I've heard that this assertion has any weight, and so I disregard it. Now, that was the finding of the learned judge. When we were in the Court of Appeal, as your lordships will have read, Court of Appeal judgment required supplemental submissions to be made about the attribution of the husband's further income.
Just a very minor point. In fact, what you showed us in the husband's affidavit said $7 million US.
Yes.
And that seems to have come out at 7.5 million euros in the judgment.
It does. I should also say on a minor point is that we've just received the transcript, some almost no evidence about this at all, but what was put to the husband was this: your wife has a clear recollection of your father discussing his wealth and saying he was worth 20 to 30 million, although she can't remember whether it is euros or dollars. So it's pounds, euros, dollars. And he says, this is not true. Did you ever hear that conversation? My father never had that amount of money, ever. And so that was the judge's findings. Now, in my learned friend's consequential submissions, if you look in Appendix 2, at page 271, paragraph 5.8, Mr. Todd wrote then, on the 9th of July 2009, for completeness, the wife still maintains the husband is the heir to a considerable fortune. Contrary to the husband's note, Mrs. Justice Barron made no findings either way about this. She did hold that there might not be an automatic inheritance as contemplated under French law because of his father's residence in England, albeit while retaining a home in Antibes. Her findings show that she doubted the husband's presentation, see paragraph 18. So having accepted here that the judge made no findings on this aspect, one way or another, we now have 6 separate references in Mr. Todd's printed case where he constructs a finding to this effect, that the husband has, as a matter of certainty or probability, got coming his way a share in 20 to 30 million pounds, dollars or euros. There was no finding to this effect, but Mr. Todd has to do this in order to make this into a Crossley type case on which his defence of the Court of Appeal decision depends. He must show to your lordships and your ladyship that this husband was at signing and is now in fact hugely rich, like Mrs. Crossley was. Now the third point of Mr. Todd...
Did the judge in fact find that because of the father's residence in England, the automatic inheritance of a share of the French property might not take effect?
Well, all you have is what she says.
Well, she doesn't say that.
She doesn't say it one way or the other. She doesn't make a finding one way or the other.
Well, she says it's subject to the French rules of forced heirship after death.
As to the house in Antibes.
Yes.
What she says, as I understand it, is that because the husband's father is resident here, there's freedom of testation, except in relation to the house in Antibes.
Yes. The house in Antibes, the house in Antibes, would be the French estate, would be the subject of forced heirship. But she's going on to say, implicitly, that she does accept that he's moved his domicile or his tax status to England, because she talks about freedom of testamentary disposition. And that can only apply if you've successfully taken your assets to England, because otherwise it would all be subject to the French forced heirship rules. And so she does, between the lines of the law, make the finding that, apart from Antibes, everything is subject to English freedom of testamentary disposition.
Because they depend on nationality, don't they, the French rules?
Yes, indeed. Indeed. So that's the second argument of Mr. Todd, that this is a Crossley type case. The first argument, this is a Crossley type case because the husband had knowledge of the wife's wealth, and so we didn't need a disclosure exercise. Second reason that this is a Crossley type case is that the judge in fact found, he says 6 times, that the husband was an inheritor in waiting of half of 20 or 30 million pounds. No finding to this effect. So what's Mr. Todd's third point to try and shoehorn this case into the Crossley box? He says that this agreement is now not unfair because the husband will not face any hardships because of 1, actual subventions from his father, 2, his earning capacity, and 3, the judge having found, indeed based her judgment on the husband's ability to equity release from his new home. Now, as to the subventions from the father, I'm not going to go through the many points in the evidence, safe to say this, and if Mr. Todd says I'm wrong, then he will demonstrate it, that in the husband's affidavits and in the solicitor's correspondence, the husband demonstrated, and this was vouched, that he had been loaned by his father £147,389 over the last 3.5 years to deal primarily with children litigation costs abroad in Germany and Monaco, and shortfalls in living expenses during those periods where the wife breached the court orders and did not pay. And yet, despite that having been clearly shown, 147389, Mr. Todd says in his printed case, page 39, paragraph 5.4d Roman 7, when speaking of the husband pursuing this appeal, and we'll come back to that a little later, he says in the third last line, in reality, the husband can afford to do this. He has an expectation of parental millions. I already read that a moment ago. His father has already lent him some hundreds of thousands of pounds during this case. My client has produced hard evidence of loans of 147389, and this becomes hundreds of thousands of pounds to show you that this is a Crossley case.
Somewhere there's a statement of assets, isn't there, which I've seen. Can you just give me there's a comparative statement of the parties' assets.
Yes, it's appended to the judge's judgment. It's Appendix 1 of the judge's judgment, and that is bound volume 2. At page 126. It's Appendix 2 to the judgment. At the time of trial, the loan from his father, this was accepted and put in the agreed asset schedule, was just under £30,000. Your Lordship see that halfway down in the husband column? There are a lot of minus figures.
Loan from father.
Loan from father, approx. $57,000. This was an agreed asset. The judge sent us out and told us to agree the asset schedule, and that's what it was at that time.
And where's the litigation loan come from?
A bank. Barclays. Now, as to earning capacity, my lords, could you turn to Mr. Todd's printed case, page 39, paragraph 5.3d Roman 3. Another reason why this is a Crossley type case where there is no hardship is because the husband will have his own earnings. Ultimately, this will be a matter of his own making. As this will be entirely in his gift, we have not sought to suggest a higher figure. It's a matter for him. We've been content to work on the modest figure of 30,000 gross per annum. However, he has the skill sets of an investment banker and will have a doctorate from the University of Oxford. He has already started patenting his biochemical processes the future appears to be full of promise. Now, it's implicit in this, and I will refer to this in more detail later, that the husband has a higher earning capacity where it was found by the judge on expert evidence that he had no earning capacity more than £30,000, and it was indeed accepted by Mr. Todd in his supplemental submissions to the Court of Appeal. And yet here we have Mr. Todd sliding away from that in order to try and shoehorn this case into the Crossley box. And finally, if you turn to page 42, at 6.3d Roman 1, in the second unnumbered paragraph of that subparagraph, third, I beg your pardon, Mr. Todd says, in paragraph 148 of the judgment, the judge expressly said that the husband would be able to equity release from the £2.5 million property if he traded down, or equity release to the reasonable figure contended before by the wife, then this would give him an extra £1.5 million. So here's Mr. Todd saying that you don't have to worry about the husband's position, and indeed you can properly treat him as being the same as Mrs. Crossley, because the judge found that he could equity release £1.5 million from his property into his Duxbury fund. Well, if you take the judge's judgment and look, please, at page 113, paragraph 140, A, in the second unnumbered paragraph of that part of the judgment, the learned judge says, I have looked at the housing particulars which have been made available, and taking judicial notice of market conditions, I consider that the husband needs £2.5 million, inclusive of costs and refurbishment, to enable him to buy a house in England and as a base for him and the girls. He has indicated that such monies as he receives for a house, subject to equity release if required over the years, will be passed to Chiara and Chloe on his death. His acceptance will be incorporated as a recital to my order, as indeed it was. So your lordships and your ladyship can immediately see that it was no part of the judge's reasoning, no part of the structure of the judgment, that this would be one of those stepped Duxburys, and I'll come to stepped Duxburys later, where it was regarded as reasonable for the recipient of the Duxbury Fund to free up at some later point equity from the home and put it into the Duxbury Fund. This was just a comment that if the husband were to find it necessary for one reason or another to equity release, that any balance of the equity will be left to his children. And so the case is completely, the facts of the case are again completely changed to fit this to the Crossley template. And so we say it's by, I was going to say a subtle, I would say not so subtle, alteration of the facts, as stated in the evidence and as found by the judge, that Mr. Todd now says this is a Crossley type case. And we submit that this case is miles away from such a scenario. What this court has to consider is whether this case, which we submit is right at the other end of the spectrum to Crossley, is also a right case for decisive weight to be granted to this prenup. So those are my submissions on my first theme. And so I come to my second theme now, my lords, my lady. Was the Court of Appeal decision permissible? Did this amount to a revolutionary piece of judicial legislation, or was it merely a fact-specific decision that correctly applied the existing law? Now, we have in our printed case argued in detail that this was a truly revolutionary piece of reasoning by the Court of Appeal, so that this case, lying as it does at the other end of the spectrum to Crossley, has been held to be one where decisive weight should be attached to the prenup. Now, we noticed that in Mr. Todd's notice of objection, but not explicitly in their case, that's at Appendix 1, page 255, but you needn't turn it up, it is said that this was merely a case of the Court of Appeal exercising its discretion differently from the judge on the existing law. And we say that were that to be adopted and asserted to your lordships, that would demonstrate considerable naivete. We submit that this decision completely alters the canvas, and we've argued this in our printed case at page 56, so I take your lordships to paragraph 131. If this case, we wrote, is a right case for being given decisive weight, as opposed to the obviously paradigm case like Crossley, then it's hard to conceive of any case not tainted with the strict contractual vitiating factors not being given decisive weight in the future. So the whole canvas has changed. Instead of a minority of Crossley-type cases being upheld, the overwhelming majority now will be. So we say that were the famous case of F&F, which is, you needn't turn it up, it's a famous case, it's in volume 3, tab 46. It's the case where, decided by Mr. Justice Thorpe in 1995, the husband had £200 million inherited. The wife was 35 with 3 children, 7, 5 and 4, 8-year marriage. 1 child was disabled. There was a prenup, under which, on divorce, she gets the pension of a retired German judge. So under the Court of Appeal's reasoning, why should that not be upheld with any shortfall, any hardship being mitigated under Schedule 1 of the Children Act? I submit it's not why should it not be upheld? It would be upheld on the reasoning of the Court of Appeal. J versus V, I will show you this. Volume 3, tab 54. Wife was 43. She had 3 children, 13, 11 and 10. There was a foreign prenup. It was a Greek prenup which gave her nothing. And in paragraph 41, the learned judge says, I should also, so page
Paragraph what?
41, at page 1052.
Yeah.
Mr. Justice Coleridge says, I should also, as a preliminary point, deal with the prenuptial agreement. I mention it only to put it to one side in this case. Nowadays, their existence can be of some significance, but not in this case. This contract was signed on the very eve of the marriage, without full legal advice, without proper disclosure, made no allowance for the arrival of children. It must, in my judgment, therefore, in this jurisdiction, fall at every fence, quite apart from the fact that the terms are obviously unfair, preventing the wife from claiming against the husband's assets. This wasn't a prenup that was vitiated by the classic contractual factors of duress or fraud. This was very similar to this prenup. So why should this prenup not be upheld after this judgment? Mrs. J or Mrs. V, I don't know which way round it is, the wife in that case, any hardship, that can be mitigated under Schedule 1. Buy her a house under Schedule 1. Give her a carer's allowance under Schedule 1. This agreement, if this judgment of the Court of Appeal is upheld, J and B would be decided in favour of upholding the agreement. M&M, in the same volume, my lords, at tab 59. This is referred to specifically by the board in McLeod. In that case, it was a 5-year marriage. The wife was 39.
Sorry, what was the reference again? 59.
59.
Sorry, I heard 40.
Canadian prenup. Wife was 39, 5-year marriage, 1 child, age 5. Wife was fully advised by QC in Canada, full disclosure. said she was under pressure. She said he wouldn't marry her unless she signed it. But it didn't come anywhere near the sort of duress that would be needed to vitiate a contract. Prenup provided in the event of divorce for £275,000. Mr. Justice Connell said he would give it some reflection, but the award should be £875,000 in his discretion. Well, this agreement will be upheld now, because any shortfall, surely, could be dealt with under Schedule 1, according to the Court of Appeal. So all these cases, one after the other, where the judges have decided, I'm sorry, it is not fair to uphold these prenups, will, if the reasoning of the Court of Appeal is upheld, be upheld.
Well, Mr. Mawson, of course, you know, I'm very new to all this, but just looking at these cases, I mean, to suggest that they all share the same sort of features as we've got here, so that inevitably, if this Court of Appeal judgment is right, those would all be differently decided, I have great difficulty with. I mean, just looking at this case, there isn't, I mean, is there the same feature of the fact of the husband being independently of some wealth? I know you quarrel with how far, having an ability to earn substantial sums, etc., etc. I mean, are you really saying that they're indistinguishable from the present case?
No, I'm not, but I'm saying, of course they're not, because I'm not going to be saying that at all, because one of my arguments coming back later on is that all these cases are decided in a fact-specific way. And indeed, that was what was said in Crossley, that they're decided in a fact-specific way. But it's very difficult to see how, if the principles enunciated by the Court of Appeal are to be upheld by this court, why M&M, the prenup, should not have been upheld with the balance being dealt with under Schedule 1.
Well, could you formulate the principle that you say has been applied wrongly here by the Court of Appeal?
Could I formulate the principle that has been applied? Yes, which is that in this case, decisive weight should be given to this prenup.
Well, on the facts of this case, what's the principle that they've decided?
The principle that they have decided is, in effect, as I will demonstrate, that in every case, absent the contractual vitiating factors, should be upheld unless it is one of real hardship. That's the principle they've enunciated. And moreover, they've gone on to say that if there are children, real hardship can be dealt with under Schedule 1 rather than under the Matrimonial Causes Act. That is the effect of the Court of Appeal's decision in this case. And, Your Lordship, I was just coming to this point, so...
Well, that'll enable you to shorten your submissions on it, won't it?
I'm doing well. I'm doing extremely well in my submissions, my Lord, and you probably think that's a relief, but...
temporarily.
What?
Temporarily well.
Temporarily well. When I say I'm doing well in my submissions, I'm doing well in getting through them, my Lord. That's sort of the point I was trying to make. No, nothing. Now, in defending this decision of the Court of Appeal, Mr. Todd says now that he has abandoned his case that these agreements should be presumptively dispositive, which was run so strongly in the Court of Appeal. At first instance, Mr. Todd, in fact, argued with Mr. Moore and Miss Booth that the test should be actually dispositive because of the Human Rights Act and the existence of what they said was a prorogation agreement under Brussels 1. But that's all under the bridge now, he says. Now he says he's not arguing this. That's page 47. Paragraph...
Can somebody remind me where this magic phrase, presumptively dispositive, comes from? I feel the family bar will know what its source is. We heard a lot of it in MacLeod. But whether that was a counsel in MacLeod...
I think Pointer printed out.
You think it's a Pointer phrase?
I think it's a Pointer phrase.
Yes. I just
It's
wondered
not,
when
it's
it
not
first...
in any of the earlier cases.
No, it's not in any of the cases.
No.
But it's in counsel's argument.
It does. I think it's a Pointer phrase.
I doubt if the average husband and wife would understand it if they were told that that was the rule.
Apart from the very clever ones, my Lord.
Apart from very clever.
Yes. Yes, it comes... I think that, in fact, it's coming back to me now.
From your left.
No, because I had to... It's coming back to me. When you did MacLeod, you were told about the great Hong Kong case of L versus C, which is an enormous great case. You went through it in great detail, which I argued in the Court of Appeal in Hong Kong. And when we researched it, we found that that was the phrase that was used by the Supreme Court of Canada in Hartshorn. So we will just check that, but we will find the phrase presumptively dispositive decision of Justice Bastaracio, if I pronounce that correctly, in Hartshorn in the Supreme Court of Canada. So when I have attributed it to Mr. Pointer, I have done him a credit that he does not deserve. Now, what I was, in relation to presumptively dispositive, can you look, please, at paragraph 6. Mr. Todd's skeleton, printed case 6.12.6, he says, we have abandoned our claim that these agreements should be presumptively dispositive. But if you turn on to his paragraph, his page 84, paragraph 9.4.
Which page was the first bit?
The first bit was 47. This, I think, answers the question that my Lord Brown was asking me a moment ago.
So where are we now?
84.
84, but paragraph number?
Is
9.4.
presumptively dispositive any more than a pompous way of saying something also quite pompous, prima facie conclusive?
Shorter.
Does it mean anything? No.
But I mean, these phrases, there are so many of these: manifestly injustice, presumptively dispositive. I mean, they're all sort of they're all inherently ambiguous and contain a sort of calculated ability for the person considering them to basically decide what they want. But you see, what is demonstrated by this case, when you go to presumptively dispositive, is as we will see, the answer to that question is it will be upheld unless there is real hardship. And we will see that that is the way it is being argued. Now, having said we're not doing presumptively dispositive, we say that this is a sort of lip service rejection, because if you look at paragraph 9.4, Mr. Todd writes, the appellant says it is not permissible to start with the question, why should this prenup not be upheld? We do not agree. If the agreement is not void for unconscionability, then a useful starting point is exactly that question. If you turn back to page 16, that this is his exact question is made clear from paragraph 2.32 Roman 3, where he says, absent those factors which would void any contract, fraud, mistake, undue influence, duress, the antenuptial contract should, in the exercise of discretion, be treated as effectively binding. Now, we say that this is, particularly, why should this prenup not be upheld, is semantically indistinguishable from presumptively dispositive or prima facie conclusive. It is exactly the same. So the abandonment is mere lip service. And Mr. Todd says that the Court of Appeal has endorsed this. Now, if that is right, then this is to change the legislation and to write into the statute words that are simply not there. Because what it comes to is this, that Mr. Todd's argument is that, in effect, the Court of Appeal has legitimately held that Section 25 is to be treated as containing a subsection, shall we call it 1 big A, that lies between 1 and 2, 1 being first interest of the children and 2 being the familiar discretionary factors, that says where there is a prenup which is not vitiated by a classic contractual factor, the court shall exercise its discretion by asking itself the question, why should this agreement not be upheld? That is what they are asking this court to say should be written in effect into the statute. Now, Mr. Todd, when he was making his submissions below, this is referred to in the judgment of Lord Justice Ricks, referred to as the genius of Section 25. Now, we don't accept that Section 25 contains genius. It might be that Mr. Todd is saying that the draftsman of Section 25 was a genius because he drafted it in such a loose way that it can be made to mean whatever a judge wants it to mean. But we do submit that you do not have to be an adherent to the Justice Scalia school of statutory construction, which is that a statute can only mean what its draftsman meant on the day that he wrote it, to see that to write those words into section 25 is beyond the legitimate judicial remit of statutory interpretation. It is, I would suggest, redolent of precisely of what Lord Atkin was complaining about in Liversidge and Anderson. I mean, it's making words mean what you want them to mean. There is no way that section 25 can be interpreted as containing the question that the discretion shall be exercised in a prenup case. Why should this agreement not be upheld? And in determining that question, he's saying that that should lie. It's the central exact question. Mr. Todd says, you turn to page 3 of his printed case, at paragraph 1.2a, he says, was this agreement vitiated at its inception? This requires evaluation of all the circumstances surrounding the creation of this agreement. Was this an unconscionable bargain? And if you then turn now to page 35, paragraph 411, he says, predictably, the question of what vitiates a person's consent has been thoroughly explored in contract law. This cannot be a closed class. There is no limit to ingenuity when it comes to trying to achieve an unconscionable agreement. And then he sets out the extract from Chitty. So he says that the question, which he says is the exact question, why should this agreement not be upheld, is to be answered in the first instance by reference to the law of contract. And then he says, having answered that question, and if the answer is no, he says the question of whether in the events that have unfolded the agreement is fair should be answered, this is my point that I made to my Lord Brown a moment ago, to the concept of real hardship. If you turn on to page 38, you will see that in answering the question, is the agreement now unjust, which is this section is about, paragraph 5.4d, having dealt with some of the facts, he says the husband is not left in a state of any real hardship by this order. And lest we had any doubt about it, over the page at paragraph 5.5, this is not a case of a husband facing real hardship. And so he says that the exact question should be answered first by reference to the law of contract, and secondly by reference to the concept of real hardship. This, my lords, is precisely the same non-statutory gloss that was put on the 1984 Act by the lower judges in the case of Agbarji, and which was very recently condemned by this court. Now, I will be referring to Agbarji in more detail later, but that was a case where this court considered the principles to be applied where there had been a foreign divorce and foreign ancillary relief order, and where a party was seeking further relief from the English court under Part 3 of the 1984 Act. And in that case, this court was confronted with a similar practice of lower courts writing into the statute words that simply were not there. Now, I think that Agbarji is in your supplemental authorities bundle 3. My Lord Collins delivered a unanimous judgment of the court, and all 5 members of the court are here today. You would turn, please, to paragraph 63. This is tab 170. 63. This is in a section which is entitled Hardship, Injustice, Exceptionality, and an award of the minimum extent to remedy the injustice, all of which were glosses that have been put by judges on the statutory test. In paragraph 63, it was held, in decisions at first instance, however, it has been held that it is only appropriate for the English court to intervene with financial relief to the minimum extent necessary so as to remedy the injustice perceived to exist without intervention. CANS, there is no statutory basis for this limitation, and it is contrary to principle. A fortiori, we would say, that in mainstream ancillary relief, there is no statutory basis for writing into the statute the exact question, why should this prenup not be upheld? And it is contrary to principle. There is nothing in section 25 at all about prenups. There is, in that part of the Matrimonial Causes Act, something about postnups in sections 34 and 35, but there is nothing in that part of the statute about prenups, let alone how they should be addressed. They are specifically left by Parliament as part of the circumstances and for the judge's discretion. But the Court of Appeal and Mr. Todd would change all this. So this again answers the question posed to me by my Lord Lord Brown. Provided there are no contractually vitiating factors, provided that the breach of the other traditional safeguards can be somehow finessed away, then what Mr. Todd calls the exact question becomes the only question. And it is virtually always to be answered in the affirmative, with any resultant hardship being dealt with under Schedule 1. So we say the Court of Appeal are right, a learned friend is right, the discretion is virtually completely abrogated and abolished. We've been thinking about in what circumstances the discretion might still come into play. And we have imagined that under this prescription that the Court of Appeal and Mr. Todd ask you to endorse, in effect, there might be a residual Section 25 discretion, we suppose, if the marriage were long and childless and it were a zero prenup. We think that perhaps there might be room for some residual Section 25 discretion under this prescription. But under the Court of Appeal decision and Mr. Todd's argument, that would be just about the only scenario. So we do say that this is truly revolutionary. We say it goes far further than any reform being proposed, and for that matter, far further than that allowed for anywhere in the common law world. And so your lordships may ask me, if that be right, Mr. Mostyn, what should be the current law? We're the top court. What should be the law? Pending the decision of Parliament about prenups. We tried to set it out shortly in our page 39 of our printed case, to which I take you. Our section Roman 9. We say that when this court enunciates principles, they should, we humbly respect this as one naturally does, make it perhaps as simple as possible, and we have endeavoured here to make it simple. Paragraph 74. First, we would submit that the governing principle of the House of Lords in White and Miller applies equally to a case where there is a prenup at large. So the search is for a fair outcome. That, you may say, is stating the obvious. You may say that the second point is stating the obvious as well, which is that the weight to be given to a prenup in the discretionary exercise under the existing statutory provisions is for the judge to determine. He or she shall give it the weight that he or she thinks fit on a fact-specific basis. We do say that in undertaking the weighing of the prenup, the judge should draw a distinction between those cases where the safeguards are being complied with and those where they have not been complied with. We submit that if a standard contractual vitiating factor is present, then it will be an exceptional case. It's hard to imagine it, where any weight is afforded to the agreement. Equally, where any one of or more of the additional factors, so that's legal advice, disclosure, provision for children, is present, we submit that the weight, if any, to be afforded to the agreement should be modest. We say if all the safeguards have been complied with, then the question is whether the provision is fair. And in those circumstances, the court will be looking to see if it is a right case. Like
Can you help it? I'm not quite sure. When what these standard safeguards, they appear in Mrs. Justice Barron's judgment really taken from a consultation paper of some sort. I mean, is that what we're speaking about now?
Yes.
They're certainly different from the standard vitiating factors in the law of contract.
They are. They're on top of.
They're on top of and more demanding.
They overlap. Yes.
And more demanding than.
More demanding. They're the same as appear in the employment legislation.
They're not. They have some obvious family similarities to the position if there is a presumption of undue influence.
Yes.
But that old-fashioned chancery phrase has not been mentioned, so far as I can see, at all in this litigation.
I think.
Or perhaps it has. It doesn't matter.
You don't want to see our original skeleton argument. I mean,
I think we've got enough.
Mr. Justice Mummy would have been proud of it in its length, but it is an immense document which does deal with Ettridge and undue influence, and there's a great tract about that. So the fact that it's not in the judgment doesn't mean it was not dealt with. But my lord, yes, the origin of these additional safeguards, which as my lord points out, they're not on top of, they overlap with the standard contractual vitiating factors. For our purposes, is the Fons et Origo is the judge's paper of 1998. Well, that's far back as we go. Although,
yes, why does that make them law?
It doesn't make them law. It doesn't make them law at all. But they have. That is what has influenced the thinking of the exercise of the discretion since then. One can see it coming up time and time again in the decisions. It was referred to, as my lord rightly pointed out, in the consultation paper supporting families, and they happen to be, and it's not, the origin is not very surprising, they happen to be the standard safeguards that are written into all the statutes in the common law world where prenups are given more recognition. As my lady said, in MacLeod, as the common law experience has shown, where legislation is enacted, particular thought is given to the content of the safeguards. And they're always the same ones.
Isn't there a risk, though, that you're reading into the discretion exactly the same fetters that you criticise the respondents for reading into them?
No, because I am at all stages saying that it's a fact-specific discretionary exercise. And in my paragraph 76, when saying what the judge should do in exercising the discretion, I'm not being remotely prescriptive. I'm simply suggesting that it will be an exceptional case in the exercise of discretion where any weight is afforded to the agreement if duress is present, for example. I would have thought that was a sort of truistic observation. I'm also going on to say that if one or more of the additional safeguards, then I'm suggesting that as a discretionary steer no more, rather than a prescriptive exact question, as Mr. Todd would have it, that the court should be affording only limited weight. But
does the last sentence of paragraph 76, should it in fact read equally where one or more of the additional factors is absent? Are you talking about safety?
Well, what I meant is, it depends on how you're looking at it. The additional factors are the need for legal advice. So if there is no legal advice, I take your lordship, yes. If one of the additional factors is absent, yes, I think that puts it better.
Yes.
But I'm not, I would resist I would defend myself from any suggestion that I am, whilst at the same time beating Mr. Todd for saying that he is writing words into the statute that aren't there, that I'm doing the same thing. Everything here has to be looked through the prism of discretion and fairness. Whereas Mr. Todd would abolish that, in effect, and that is what happened in this case. As we've seen from the Court of Appeal decision in this case, Lord Justice Wilson makes no excuses for this. It's quite clear he says that there shall be no exercise of discretion except under Schedule 1 because of the highly prescriptive analysis, intellectual analysis he has set himself. And then we've gone on to say, I just want to finish this paragraph 78, if all the safeguards are in place, this is an important point, as was the case in M&M, but the provision is nonetheless considered to be a long way from the result that would have been ordered absent the agreement, then it is permissible to adjust the award downwards to the bottom of the bracket to reflect the existence of the agreement. Now, in that case, the assets were about £5 or £6 million, and the wife got just under £1 million, which is a long way short of what, well, not a long way short, is short of what she might have got absent the agreement. But the adjustment downwards gave some weight to the agreement, even though the award was very significantly more than was provided for in the agreement. But we do make the point that the award must still, in the end, be in the zone of fairness. And we do say, this is what divides myself and my learned friend, we say it is not permissible to start with the question, why should this prenup not be upheld? That is the clear blue water between the two cases. And as we will show, that is what Lord Justice Wilson effectively did in this case. So that is my...
Your starting point is, you say, what is the minimum that fairness demands?
Yes.
You're going to get that anyway. That's where you start.
Yes.
Regardless of...
That's the basis.
Yes, that's your starting point.
That's our basis. We say that is that the fair result, the prescription of fairness, as again in White and reiterated in Miller, applies to every case, the Catholic principle. Now, my next point in this theme was it permissible for the Court of Appeal to ignore the decision of the board in MacLeod? And we do say that the Court of Appeal decision was doubly revolutionary because it refused to follow the clear line given by the board. We have explained in our printed case that where the legislation is the same, the Court of Appeal ought to treat any pronouncements from the board as having the same status as coming from the House of Lords or this court. And on page 44 of his printed case, what Mr. Todd says, at paragraph 6.5b, that the departure by the Court of Appeal was acceptable because what the board said about prenups was overturned. MacLeod was a post-nup case, not a prenup case. We do submit that if the top court gives guidance, even overturn guidance, then lower courts should hesitate long and hard before disagreeing with it. And the disagreements are manifold. I'm not going to go through it, I'm just going to give you the paragraph references in the Court of Appeal judgment where there is explicit disagreement with the Privy Council. Lord Justice Thorpe, paragraphs 14 and 25 to 29. Lord Justice Ritz, paragraph 65. Lord Justice Wilson, paragraphs 119, 124 to 128, and 134. And in those paragraphs, we find the clearest expressions of disagreement as to four things. One, whether voidity for public policy reasons should be maintained.
Who coined that one?
Lord Justice Wilson. It's in his judgment.
Yes,
it's in his judgment. We think it's a good word. Yeah. It's not in the Oxford English Dictionary. We looked it up in the big one, but we think it's a good word. It's better than voidness.
How does it differ from nullity?
Exactly.
It's in the judgment. When a Lord Justice uses a word, my Lord, who are we?
You
another one.
No, you endorsed it. You thought it was a good word.
I thought it was a good word.
Why do you think it's a good word?
Because it sounds good. Yeah. All right, whether nullity, I've got the way that wind is going in this one, whether nullity for public policy reasons should be maintained. It's the first clearest expression of disagreement. Secondly, they disagree that there are significant conceptual and factual differences between a prenup and a postnup. Thirdly, they disagree as to whether observance of the safeguards matters. And fourthly, they disagree as to whether postnups should be recognised and varied under the specific statutory provisions enacted for that purpose, as the board said. Now, as to the continuance of nullity, we submit naturally that the reasoning for that, as given in MacLeod, is wholly persuasive and should be followed by this court. Now, Mr. Todd says at page 13, he says this here in a number of other places, at paragraph 2.26,
4.
What is the paragraph? Prenuptial agreement, says Mr. Todd, remain, per Baroness Hale and MacLeod, void for contractual enforcement for long-standing policy reasons. This requires real emphasis, underlined only insofar as they are expected to be given contractual force. Now, what was said in MacLeod, this is in volume 4, tab 6. My lady said, the board takes...
Paragraph
31. I'm so sorry, I didn't say that. The board takes the view that it is not open to them to reverse the long-standing rule that anti-nuptial agreements are contrary to public policy and thus not valid or binding in the contractual sense. Now, what Mr. Todd has done is seized on that. He's eliminated the word thus and asked you to accept that the nullity here has only some very limited or attenuated expression, which is this, that these agreements, in effect, says Mr. Todd, should be treated as if they are valid, save insofar that they cannot be sued on contractually. That is not what the board was saying.
Where do we find that in
Yes,
Mr. Todd's case?
I didn't pick it up either.
Yes, it's at paragraph 2.26.
Well, that's what you said.
That is there. 2.26. Freedom to contract, he says.
Yes, only insofar as they are expected to be given contractual force. Thus, he says, they are not akin to those contracts, such as contract killing, where the contract is void ab, I should have read this on, void ab initio, and everything that flows from it is a nullity. Here the Baroness is not saying anything more than these agreements are not to be given contractual force, but they can be a Section 25 factor. It is probably time to drop this confusing moniker, very dramatic, and adopt the more widely adopted phraseology.
Yes, I'm afraid things have broken down a bit because it's not in the draft of the case we've been using. It's in the bound volume.
It is.
It's a different numbering, 2.25, I think.
I'm not responsible for this.
Yes.
You can have a go at Mr. Todd about this, but I'm not responsible about this.
Bill Collins has sort of promised.
Okay, so I'm reading from the second edition,
Yes.
which is in the bound volume, at 2.26, page 13.
Yes.
I have not brought the first edition with me, so I can't help you on that. It's sitting in my desk in chambers.
But I'm sorry, I mean, I am reading the second edition. What's wrong with the second edition?
The second edition, it seems to be saying that these are not really void at all. They're only void in some kind of limited way.
Well, that's right, they're not given contractual force. I mean, if they were contrary to public policy in any usual sense of it, it would be an impermissible consideration under Section 25. You can't have regard to considerations that are contrary to public policy.
Yes, but that's why we've argued we're in a strange state of... It is a strange state of affairs.
Well, it's accurately represented, isn't it, in that paragraph 2.26?
They are not akin to those contracts where the contract is void ab initio and everything that flows from it is a nullity. I agree with that. The Baroness is not saying any more than that these agreements are not to be given contractual force, but they can be given a Section 25 factor. I don't agree with that, but my lady will tell me if I've interpreted it correctly. She is going much further than that in paragraph 31. She is saying that it remains a void contract. She's not saying it's just void in a technical sense, and therefore we will give it proper expression. She's saying it remains void, and its voidness or its nullity is a matter to be considered by Parliament.
But why does it remain void? I mean, it obviously can't be enforceable because of Section 25. So it can't have contractual force. But as my Lord says, if it is void because there is something fundamentally repugnant, morally objectionable or legally objectionable about it, we should be giving it no force whatever.
I agree with that.
I mean, if it's like a conspiracy to kill someone, or which is the
Trading
example given here.
Trading with the enemy.
Or trading with the enemy, yes. But it isn't. It obviously isn't.
But are you saying MacLeod is to be read as if it is to say
No.
you ignore them?
No, I'm not, because
Well,
of
then
course...
I'm not.
Because, of course, I've accepted that in the right case, it can be given decisive weight, and Crossley is an example of the right case. What I'm quarrelling with, and this may be just a semantic dispute, and I'll move on from it very quickly, I'm quarrelling with my learned friends' attempt to diminish the effect of what my lady said in MacLeod by trying to say that it is only void in a highly technical and limited way. The answer to my Lord's question is that the board did identify 3 reasons why they should remain void, and that's on page 10 of our printed case at paragraph 22. I accept entirely that the old Victorian reason,
Sorry,
page 10 of our printed case, paragraph 22. Now, we have accepted entirely on the previous page that the old Victorian reason of imposing public policy voidness on these contracts, namely because they undermine the duty to cohabit, has gone, went in 1970 by statutory reform. And so that particular reason for voidness of nullity of PNC, prenups, went by the wayside in 1970. But the board rightly maintained nullity for these contracts for 3 reasons, which is our paragraph 22. And we're going to come to these in greater detail. 1, they are completely different in practice and principle from a postnuptial contract. 2, that were they to be declared valid and enforceable, as my lady said, they would not be directly variable by the court, which would be a strange and perverse state of affairs where there is specific variation powers enacted by Parliament for a purpose, for one type of contract, but they wouldn't be available for the other. And thirdly...
Is that common ground that on this point at least, Mrs. Justice Barron got it right?
Yes. Is that common ground? I said yes. Well, it's
you've got a nod to your left.
Have I got a nod? Yeah. Good, excellent. Yes, the answer is yes.
I don't understand the point, though, because you don't need them to be variable if they're not binding. The Matrimonial Causes Act does it all.
Well, my lady did explicitly say that this was a reason, which would say that if Parliament is going to legislate and make certain types of agreements both valid and variable, then it would be, well, not so much perverse, but it would be counterintuitive for it to maintain or for it to create validity in relation to another type of agreement which is not dealt with in the statute. That was my lady's point in MacLeod.
But all this is saying is that they are not to be treated as binding in law. That's what's meant by validity.
Yes.
Under the old rule of public policy, they would because of the public policy, it wouldn't be wrong to have regard to them at all. That public policy is gone,
Yes.
so that they're not reinstated as binding legal contracts, may be subject to provisos, but they are not to be treated as a contract that has been rendered null by a rule of public policy.
Because the main rule has gone.
The main rule has gone.
But the board identified 3 reasons why the rule should be...
Why they shouldn't be contractually binding.
Yes, I think they're going further than just contractually binding.
Well, I have the same difficulties as my lord. I don't see the word nullity in paragraph 31. And what reading this as a relative newcomer to the discipline, I thought that what was being done in that first sentence of paragraph 31 was simply to explain the effect of the reverse, the effect of the first part of the sentence, that is not valid or binding in the contractual sense, and that's an important qualification. But
it is.
It doesn't, I think, at least I didn't read it as going as far as to tell us that it was a nullity and therefore you disregard it.
But that's not my case.
Well, you do use
it's not my case, because if you turn back in our printed case, I feel I'm being pushed into a corner when I'm going to be saying something which I'm not saying.
Well, you were using the word nullity.
Yeah, not my word, nullity. But anyhow, if you look at page 5...
Maybe we ought to go back to voidity.
Voidity.
Something a little short of nullity.
Yes, something short. If you go back to page 5...
Sorry, page 5.
Page 5 of my printed case.
Yes, paragraph number
7.
Thank you.
Start at 6. The present status, we've tried to do this, of prenups in English law, In contrast to the post-nup, a prenup remains void as contrary to public policy. Moreover, if a provision in a prenup purports to restrict access to the divorce court, then that particular provision is additionally void under Hyman. Notwithstanding use the word of the prenup, it may still be considered by the court and afforded such weight by the trial judge as he or she, in the exercise of exclusive discretion, thinks fit in order to achieve a fair outcome, which is the overriding objective. It is an unusual state of affairs for a court to be attributing weight to an instrument that is void, as against public policy, or to the circumstances surrounding the creation of such a document. So I don't want to be any doubt as to what our position is. We accept that entirely. And so that interesting argument that the Privy Council was regaled with by Mr. Legrice about, in physics you can't have a weight and a void, so why should you in matrimonial law? I'm not going there. We accept that in the right case, which is a cross-type type case, it can even be given decisive weight. All I'm quarrelling about, and I've wasted far too much time on this, and if you think it's a bad point, I'll move on quickly, is that I do not agree with my learned friend's submission that all my lady was saying in MacLeod was that it was technically void.
Would it be more helpful to say they're unenforceable?
Unenforceable.
And the point is that they're unenforceable either way.
Yes.
Suppose, for example, that you had a prenup that said, in the event of our separating, you will be entitled to £10 a week, max. Not only can the person who wishes to limit the sums payable to £10 a week not rely on it contractually, but the person who wishes to enforce it for the £10 a week can't rely on it. That's the point.
It's a two-way street.
Yeah. And that's why it's not a contract in the normal sense of the term. I believe.
Yes.
It's not for me to try and explain what I...
No, I accept that entirely. If I've wasted your time with sort of railing against this, then I apologise. I think that we've all reached common ground on that. We do submit that in relation to MacLeod, this is my final point about MacLeod, that the Court of Appeal, we submit, was not at liberty to disregard the clear message from the board.
What were the three reasons that you said came from the board? I mean,
There are my paragraph 22.
Yes.
The enormous difference, conceptual and practical differences, the enormous conceptual and practical differences between postnups and prenups.
Oh, and more appropriate is the third one, yes. 2
is enforceability, direct enforceability. Parliament has legislated to make postnups directly enforceable and variable. And thirdly, that they should remain unenforceable and void because the issue of their validity and effect is more appropriate to legislative rather than judicial development.
What are you contemplating in paragraph 22.2, when you say valid and enforceable? That's valid and enforceable in a contractual sense.
Well,
I can't see the point of saying that since we've been in the council totally isn't.
This is in MacLeod, my lady explained how a postnup, Parliament intended that a postnup, and this would include an agreement made just after the marriage, or a separation agreement made when after the parties are separated in contemplation of a divorce, or a compromise agreement of a claim for ancillary relief which hasn't by then been translated into a court order. All those three. She explains how we have been operating on the wrong basis for years in dealing with these under Section 25, when Parliament has specifically legislated that these should be dealt with within the four corners of Sections 34 and 35. There is specific legislation directed at these agreements. And so when my lady said in MacLeod...
Well, that's not excluding their relevance for the purpose of Section 25.
Oh, no, because Section
Because
25,
if you've got ancillary relief proceedings on foot, well, anything trying to oust them is void, and so you can...
Yes.
You start, in a sense, with a clean slate.
Your point was that this was the starting point. It should be done, as you said, when dealing with the case of Edgar and Edgar. You said the solution would have been more obvious if mention had been made of the statutory provisions relating to the validity and variation of maintenance agreements. But I am going to answer my Lord Hope's point, is that my lady then did say, however, that because Parliament had not specifically legislated for a prenup, and therefore that a prenup cannot be directly considered under sections 34 and 35, that was a reason to maintain the nullity of those contracts. That was explicitly said. I just find the paragraph when
I found it reading before. I can't put my finger on the...
Yeah, I'm sorry, it's 5 to... might give it at 2 o'clock because I've had a lost moment on that.
But anyway, Mr. Todd isn't challenging that. No. All the argument is about how much weight it should carry and in what circumstances.
It is. As I've said, at the end of the day, you have to decide a fairly narrow question on the facts of this case, which is this case a Crossley type case, the right case in which to give decisive weight? So we submit, in other words, that the Court of Appeal was not at liberty to disregard the clear message from the board. This very decision of Granatino was, by Mrs. Justice Barron, the first instance decision was indeed considered by the board. It may be going too far for me to say that it was implicitly approved, but certainly some of the statements made by the learned judge were approved.
Well, only the point, as I recall, that section 34 and 35 did not apply to prenups.
Yes, but you also cited, if you look at
2728.
Yeah, 2728. Thank you. Go ahead. We do say that the decision of McLeod and the reasoning of the board should have been afforded proper as opposed to synthetic respect by the Court of Appeal. Now, my next point under this theme is, was the Court of Appeal entitled to interfere with the judge's discretion? I'd wonder if your lordships would want me to do that at 2 o'clock.
Very well, we'll do it at 2 o'clock.
They can't get me too easy. Is that mine or yours? These are all mine.